Title 3, Board of Directors, Trustees, Officers. Section 23, the Board of Directors or Trustees. Unless otherwise provided in this code, the corporate powers of all corporations formed under this code shall be exercised. All business conducted and all property of such corporations controlled and held by the Board of Directors or Trustees to be elected from among the holders of stocks, or where there is no stock, from among the members of the corporation, who shall hold office for 1 year until their successors are elected and qualified. Every director must own at least 1 share of the capital stock of the corporation of which he is a director, which share shall stand in his name on the books of the corporation. Any director who ceases to be the owner of at least 1 share of the capital stock of the corporation of which he is a director shall thereby cease to be a director. Trustees of non-stock corporations must be members thereof. A majority of the directors or trustees of all corporations organized under this code must be residents of the Philippines. Section 24, Election of Directors or Trustees. At all elections of directors or trustees, there must be present, either in person or by representative authorized to act by written proxy, the owners of a majority of the outstanding capital stock, or if there be no capital stock, a majority of the members entitled to vote. The election must be by ballot if requested by any voting stockholder or member. In stock corporations, every stockholder entitled to vote shall have the right to vote in person or by proxy the number of shares of stock standing at the time fixed in the bylaws in his own name on the stock books of the corporation, or where the bylaws are silent at the time of the election, and said stockholder may vote such number of shares for as many persons as there are directors to be elected, or he may cumulate said shares and give one candidate as many votes as the number of directors to be elected multiplied by the number of his shares equally, or he may distribute them on the same principle among as many candidates as he shall see fit, provided that the total number of votes cast by him shall not exceed the number of shares owned by him, as shown in the books of the corporation, multiplied by the whole number of directors to be elected. Provided, however, that no delinquent stock shall be voted, unless otherwise provided in the Articles of Incorporation or in the bylaws. Members of corporations which have no capital stock may cast as many votes as there are trustees to be elected, but may not cast more than 1 vote for 1 candidate. Candidates receiving the highest number of votes shall be declared elected. Any meeting of the stockholders or members called for an election may adjourn from day to day or from time to time, but not sine die or indefinitely, if for any reason no election is held or if they're not present or represented by proxy at the meeting. The owners of a majority of the outstanding capital stock, or if there be no capital stock, a majority of the members entitled to vote. Section 25, Corporate Officers, Quorum. Immediately after their election, the directors of a corporation must formally organize by the election of a president, who shall be a director, a treasurer who may or may not be a director, a secretary who shall be a resident and citizen of the Philippines, and such other officers as may be provided for in the bylaws. Any two or more positions may be held concurrently by the same person, except that no one shall act as president and secretary, or as president and treasurer at the same time. The directors or trustees and officers to be elected shall perform the duties enjoined on them by law and the bylaws of the corporation, unless the articles of incorporation or the bylaws provide for a greater majority, a majority of the number of directors or trustees, as fixed in the articles of incorporation, shall constitute a quorum for the transaction of corporate business, and every decision of at least a majority of the directors or trustees present at a meeting at which there is a quorum shall be valid as a corporate act, except for the election of officers, which shall require the vote of a majority of all the members of the board. Directors or trustees cannot attend or vote by proxy at board meetings. Section 26. Report of election of directors, trustees, and officers. Within 30 days after the election of the directors, trustees, and officers of the corporation, the secretary or any other officer of the corporation shall submit to the Securities and Exchange Commission the names, nationalities, and residences of the directors, trustees, and officers elected. Should a director, trustee, or officer die, resign, or in any manner cease to hold office, his heirs, in case of his death, the secretary or any other officer of the corporation, or the director, trustee, or officer himself, shall immediately report such fact to the Securities and Exchange Commission. Section 27. Disqualification of directors, trustees, or officers. No person convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years, or a violation of this code committed within 5 years prior to the date of his election or appointment shall qualify as a director, trustee, or officer of any corporation. Section 28. Removal of officers or trustees. Any director or trustee of a corporation may be removed from office by a vote of the stockholders holding or representing at least 2/3 of the outstanding capital stock, or if the corporation be a non-stock corporation, by a vote of at least 2/3 of the members entitled to vote, provided that such removal shall take place either at a regular meeting of the corporation or at a special meeting called for the purpose, and in either case after previous notice to stockholders or members of the corporation of the intention to propose such removal at the meeting. A special meeting of the stockholders or members of a corporation for the purpose of removal. A special meeting of the stockholders or members of a corporation for the purpose of removal of directors or trustees or any of them must be called by the secretary on order of the president or on the written demand of the stockholders representing or holding at least a majority of the outstanding capital stock, or if it be a non-stock corporation, on the written demand of a majority of the members entitled to vote. Should the secretary fail or refuse to call the special meeting upon such demand, or fail or refuse to give the notice, or if there is no secretary, the call for the meeting may be addressed directly to the stockholders or members by any stockholder or member of the corporation signing the demand. notice of the time and place of such meeting, as well as of the intention to propose such removal, must be given by publication or by written notice prescribed in this code. Removal may be with or without cause, provided that removal without cause may not be used to deprive minority stockholders or members of the right of representation to which they may be entitled under Section 24 of this code. Section 29. Vacancies in the office of director or trustee. Any vacancy occurring in the Section 29. Vacancies in the office of director or trustee. Any vacancy occurring in the board of directors or trustees other than by removal by the stockholders or members or by expiration of term may be filled by the vote of at least a majority of the remaining directors or trustees, if still constituting a quorum. Otherwise, said vacancies must be filled by the directors in a regular or special meeting called for that purpose. A director or trustee so elected to fill a vacancy shall be elected only for the unexpired term of his predecessor in office. A directorship or trusteeship to be filled by reason of an increase in the number of directors or trustees shall be filled only by an election at a regular or at a special meeting of stockholders or members duly called for the purpose, or in the same meeting authorizing the increase of directors or trustees, if so stated in the notice of the meeting. Section 30. Compensation of directors. In the absence of any provision in the bylaws fixing their compensation, the directors shall not receive any compensation as such directors, except for reasonable per diems, provided however that any such compensation other than per diems may be granted to the directors by the vote of the stockholders representing at least a majority of the outstanding capital stock at a regular or special stockholders meeting. In no case shall the total yearly compensation of directors as such directors exceed 10% of the net income before income tax of the corporation during the preceding year. Section 31. Liability of directors, trustees, or officers. Directors or trustees who willfully and knowingly vote for or assent to patently unlawful acts of the corporation, or who are guilty of gross negligence or bad faith in directing the affairs of the corporation, or acquire any personal or pecuniary interest in conflict with their duty as such directors or trustees, shall be liable jointly and severally for all damages resulting therefrom suffered by the corporation, its stockholders or members, and other persons. When a director, trustee, or officer attempts to acquire or acquires in violation of his duty any interest adverse to the corporation in respect of any matter which has been reposed in him in confidence, as to which equity imposes a disability upon him to deal in his own behalf, he shall be liable as a trustee for the corporation and must account for the profits which otherwise would have accrued to the corporation. Section 32. Dealings of directors, trustees, or officers with the corporation. A contract of the corporation with one or more of its directors or trustees or officers is voidable at the option of such corporation unless all of the following conditions are present. 1. That the presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting. 2. That the vote of such director or trustee was not necessary for the approval of the contract. 3. That the contract is fair and reasonable under the circumstances. 4. That in case of an officer, the contract has been previously authorized by the board of directors. Where any of the first two conditions set forth in the preceding paragraph is absent, in the case of a contract with a director or trustee, such contract may be ratified by the vote of the stockholders representing at least 2/3 of the members in a meeting called for that purpose, provided that full disclosure of the adverse interest of the directors or trustees involved is made at such meeting, provided, however, that the contract is fair and reasonable under the circumstances. Section 33. Contracts between corporations with interlocking directors. Except in cases of fraud, and provided the contract is fair and reasonable under the circumstances, a contract between two or more corporations having interlocking directors shall not be invalidated on that ground alone, provided that if the interest of the interlocking director in one corporation is substantial and his interest in the other corporation or corporations is merely nominal, he shall be subject to the provisions of the preceding section insofar as the latter corporation or corporations are concerned. Stock holdings exceeding 20% of the outstanding capital stock shall be considered substantial for the purposes of interlocking directors. Section 34. Disloyalty of a director. Where a director, by virtue of his office, acquires for himself a business opportunity which should belong to the corporation, thereby obtaining profits to the prejudice of such corporation, he must account to the latter for all such profits by refunding the same, unless his act has been ratified by a vote of the stockholders owning or representing at least 2/3 of the outstanding capital stock. This provision shall be applicable notwithstanding the fact that the director risked his own funds in the venture. Section 35. Executive Committee. The bylaws of a corporation may create an executive committee composed of not less than 3 members of the board to be appointed by the board. Said committee may act by majority vote of all its members on such specific matters within the competence of the board as may be delegated to it in the bylaws, or on a majority vote of the board, except with respect to 1. Approval of any action for which shareholders' approval is also required. 2. The filing of vacancies in the board. 3. The amendment or repeal of bylaws or the adoption of new bylaws. 4. The amendment or repeal of any resolution of the board which by its express terms is not so amendable or repealable. And 5. A distribution of cash dividends to the shareholders.